In the 1950s, drug manufacturer Merrell Dow Pharmaceuticals developed a breakthrough pregnancy drug called Bendectin. Over 33 million women worldwide used Bendectin to soothe the symptoms of morning sickness. But a number of women taking Bendectin gave birth to children with severe deformities. Lawsuits brought by families who blamed Bendectin for the defects became so numerous and expensive that Merrell Dow took the drug off the market in 1983. Despite the allegations against Merrell Dow, it was never clear that Bendectin actually caused birth defects, even after the drug was taken off the shelves. Jason Daubert and Eric Schuler were born with birth defects to mothers who took Bendectin. Their families brought a case against Merrell Dow that eventually reached the United States Supreme Court. Unsurprisingly, the attorneys in Daubert v. Merrell Dow Pharmaceuticals argued fiercely over whether Bendectin actually caused the children's birth defects. Merrell Dow relied on established scientific findings, pointing to over 30 published studies on Bendectin, none of which showed that the drug caused birth defects. The plaintiff's attorneys countered with 8 expert witnesses, all with impressive credentials, who believed that Bendectin caused birth defects. These experts did not base their opinions on the accepted conclusions of studies on the drug's effects on humans. Instead, the experts relied on indirect evidence, including tests on animals, evaluations of the drug's chemical makeup, and reanalysis of previous studies. The Federal District Court in California applied the common law Frye test and ultimately decided that the plaintiff's expert testimony was inadmissible. The test, named for the 1923 case Frye v. United States that established it, required that admissible scientific expert testimony be based on principles that are, quote, generally accepted, unquote, by the scientific community. The indirect studies that the plaintiff's experts relied on did not meet this test. Therefore, the district court granted summary judgment for Merrell Dow. On appeal, the United States Court of Appeals for the Ninth Circuit agreed. The plaintiffs petitioned the U.S. Supreme Court for cert. The court granted the request. The issue for the Supreme Court was whether the Frye test was still applicable following the adoption of the federal rules of evidence in the early 1970s. The court had to decide whether scientific expert testimony still had to be based on generally accepted methods to be admitted in federal courts. The Supreme Court concluded that Rule 702 of the Federal Rules of Evidence had replaced the 70-year-old Frye test. Justice Blackmun, writing for the majority, noted that to be admissible as evidence under Rule 702, a proposed scientific expert's testimony must, quote, be based on sufficient facts or data and be the product of reliable principles and methods, unquote, which must be applied to the facts of the case. The drafters of Rule 702 never used the words general acceptance or otherwise tried to codify the Frye test. Instead, the drafters purposely broadened the scope of admissible expert testimony. The Frye test had generally excluded new, cutting-edge scientific methods that may not have yet been generally accepted. But the federal rules of evidence superseded the common law rule and opened the door for the evidentiary use of new scientific techniques. Justice Blackmun went on to provide guidance in applying Rule 702. Expert testimony must be rooted in valid scientific methods that can produce consistent, reliable results. General acceptance, while instructive, was not necessary. Blackmun also made clear that all the rules of evidence, not just Rule 702, apply to scientific expert testimony, including rules that require the evidence to be relevant and assist in determining issues of fact. In Jason and Eric's case, the expert testimony met these conditions and should have been admitted. Justice Rehnquist, joined by Justice Stevens, concurred that Rule 702 replaced the Frye test, but partially dissented. Rehnquist argued that Justice Blackmun's guidance was vague and unfairly required judges to play amateur scientist in determining whether a particular method is scientifically valid. Rehnquist didn't think that Blackmun's guidelines should have a binding effect on future courts. The Daubert decision overruled the common law Frye test for admitting scientific expert testimony. By establishing the primacy of the federal rules of evidence, Daubert opened the door for new techniques, both scientific and otherwise, to be used in federal cases.